Mad Dad here. This video is for parents dealing with the domestic violence situation, and particularly the restrained party. Okay, and you're dealing with a domestic violence situation. You have children involved, and the restrained party, mom or dad, wants to be more involved in the kids, who wants to establish or wants to gain their custody back. Okay, and now if you have already got this, if you already have a restraining order, in most cases you don't have any custody. Okay, you may have some form of visitation, whether it be supervised, unsupervised, professional supervision, every other week, week on, week off, whatever the case may be. But you want to get some form of custody back. Okay, now you have to understand a couple things before even approaching the courts with an action to basically, not appeal the decision, but to ask for a modification or to change the physical or the custody orders. Okay, one thing is you have to understand this: for 5 years, okay, there's a rebuttable, presumed. Uh, it's like it's like a rebuttable presumed assumption. Okay, that having the children, you having custody of the kids, whether it be sole custody or joint custody, it's not in the kid's best interest. Okay, now this is a rebuttable presumption. All right, now this presumption is just based on the fact that you have a domestic violence restraining order against you. All right, you're already the bad guy. Okay, and so what you have to do is you have to for 5 years, this is going to be over your head. You're going to have the cloud over your head. Now, if you're trying to gain your custody back, you have to rebuttal the fact that it's presumed that the children, that it's not in your interest to have, not in the children's interest for you to have custody. You have to rebuttal this to the courts, and this is how you have to do it. Okay, in most cases. All right. Now, again, check with an attorney, check with whoever it is that you check with in regards to this. This is not advice. I'm not an attorney. Okay, but for those who want to listen, all right, this is what you have to do. First off, you need to make sure that you're going to all of your batter cap classes, your batter intervention, your whatever, your anger management, whatever classes they have. Typically is like 52 weeks for 1 year, or 26 weeks, 6 weeks, half a year. But you want to make sure you start going to these classes. Okay, you want to be consistent with these classes. All right, you want to basically at least complete a minimum of half those classes. So if you have 52 weeks, you want to complete at least 26. If you have 26 weeks, you want to complete at least 13, okay, of those classes. All right, and you want to complete your co-parenting class. More than likely, you're going to have to go to some form of co-parenting course. You're going to take some form of co-parenting course. Some form of co-parenting course, whether it be online, in person, whether it be co-parenting, or it just be for you. You're going to have to go through that, okay? The next thing is you're going to have to keep up with you're going to have to establish, okay, some form of visitation. All right, more than likely, well, not more than likely, in some cases you're going to have professional supervision, you're going to have non-professional supervision, you're going to have weekends, whatever it is. Okay, you're going to have to, and if you don't have anything, if you have no visitation, okay, your shit was so bad that you don't have any visitation, okay, poor thing you, but you're just going to have to start with whatever the courts will give you. And basically you want to, in order, before you even establish any form of trying to seek any form of custody, it is wise to make sure that you have some form of visitation established. Okay, now what you'll want to do is you'll want to make sure, again, you want to make sure that you're going to your anger management classes. You have at least half of them complete. You have completed your visitation is going on. You've taken care of your visitation. All right, you're going visitation. If there's a child support order established, okay, if there's a child support order established, then you will want to make sure that you're paying your child support. If you're not able to pay the full amount, you want to make sure that you're paying towards your child support. Okay, and you're being consistent. Now, in regards to this, you also, pretty much what I would do. Okay, or you know what is a good idea is to basically, when you go to, you know, if you've already taken care of at least half the courses, if you've already if you're paying, you know, you're on a routine and you're keeping committed to your schedule, that you have your visitation schedule. If you have one, you're keeping committed to your visitation schedule. And again, let me press pause. If you have no visitation schedule, okay, there ain't no reason for you to be trying to go get no type of custody or legal, whether it be legal or physical. Okay, you want to go ahead and you want to start off with establishing a visitation schedule. But for those who have a visitation schedule, okay, what you'll want to do is you'll want to make sure that you have, you know, you've been consistent for that visitation schedule for at least about 6 months. Okay, so some of you guys may say, damn, 6 months, you know, that's a long ass time. I can't wait 6 months. Too bad. Okay, more than likely, yeah, you can go before 6 months, but you know, more than likely nothing is going to move because you haven't established a consistent routine. You know, you know, and in fact, you want to make sure those classes are taken care of, or you know, and that, you know, you don't have, you know, you have at least half of those done. Okay, so getting back to it, you have, you know, you've taken care of all those things, and you want, you know, now you want to go ahead and after you have completed that, you know, for about 6 months, then you'll want to probably approach the court with a request for order. Okay, and a request for order will be to establish or to change the custody, you know, the legal and physical custody to maybe joint. Okay, and what, you know, and as an extra, what you'll want to do is, if you have, you know, you'll have a visitation schedule, what you'll want to do is you'll want to ask to basically increase your visitation schedule as well, since it's on the ballot. And while you're at it, okay, is what's probably a good idea to ask for, if you know, if you think it will be in your interest, is to basically like a 3111. You know, I believe it's a 3111 or a 730, 740, one of those. Okay, it's like an evaluation. It's going to allow the kids to be evaluated. You know, you can ask that, you know, the living situations from, you know, in regards to the homes be evaluated to see if it's in the kids' interest. Sometimes that will benefit you. Like sometimes, you know, you will have where the primary parent or the protected party is basically staying with friends, or the protected party is living, you know, with his or her boyfriend or whatever, you know, or girlfriend, you know. You know, different situations where, you know, that on the protected party, that's it, where you have, you know, a home where, you know, the kids have their own rooms, and you know, the kids are able, you know, that may work to your benefit, but it's not going to guarantee anything, but it's going to work. It may work to your benefit, but in order for the courts to recognize that and take notice of that, you know, it's best to have an evaluation done. So you can file, you know, a request for order. You will basically ask to change the custody and legal, you know, the physical and legal custody. You would also ask for to change visitation. Okay, like I said, you want to increase visitation. If you have supervised visits, you may want to ask the courts to change it to unsupervised visits, or if you have unsupervised visits, you may want to ask the courts to increase it to supervise, to weekends, or whatever the case may be. Okay, personally, you know, for me, I go all out. Okay, it's a compromise, so I would go in and just ask the courts for you know, whatever it is I want, and let them talk me down. You know, it's a negotiation. They're going to do what they're going to do anyway. I'm just making that pitch, and hoping that, you know, someone takes notice to it. You know, now getting back to it, you will want to go ahead. You want to have your, you know, you want to have all your ducks in a row. So you'll get ready. You know, you'll prepare your request for order. I believe that's like the FL 300, and you'll want to make sure that you have your parent, you know, you'll want to show the court, you know, attach a document, you know, attach documents in regards to your parenting classes, in regards to how many courses you completed at the anger management. You'll be asking for, and in your declaration, you'll ask for, oh, wait a minute. Give me 1 second. You're going to do you're going to have attached to your declaration, make attachments for your classes, for your parenting class, how many courses how many classes you completed for your anger management course, and also keep a calendar, a schedule. Okay. Well, hell, two more things. If you have you want to keep a schedule or a calendar, you want to provide, like, you can write it out, or you can get a little small little calendar, and you can mark all the times that you have, you have the child, okay, in your visitation, and every time that you've been there, you've been consistent. So you want to just, a simple little calendar. And if there's a child support order established, you want to make sure that you're paying your child support and you're honoring that order, okay? And you're basically can show a printout, a payment history, however you keep your records. Hopefully you're not giving cash. That's a dumbass move, to give cash in regards to any child support situation. One sec. So that's a real foolish ass move. So you don't want to do that. So whatever record keeping, if it's going through the Department of Child Support Services, that's great, because then you can just contact them, ask them for a payment history. And they'll send one to you, or you can go there. You get the payment history. Boom. Excuse me. Everything is all good. So now you have those 4 things or 3 things attached to your declaration. Now in your declaration, you may want to go ahead and ask the courts to do let the courts know, give the courts a little background about what's going on, and you want to let the courts know that you want to make 2 positions. You want to, well, 3. You want to ask the courts for evaluation. If it's up to you, but it's probably a good idea to ask the courts for evaluation of the households, or to interview the kids, or both. To just ask the kids, whether or not they want to be with you, they want to see you, they want to spend time with you. Then you want to ask for a temporary step up visitation schedule. So you may want to just say, hey, I'm asking, for this investigation, but it's supposed to go on for 60 days, or while the investigation is going on, I would like the courts to implement a temporary schedule, visitation schedule. My current schedule is at supervised visits, or at every other weekend, whatever it is. But now I would ask for unsupervised visits, or now I will ask for every other weekend with 1 day during the week, or overnights, or whatever the case may be. You will ask for an increase while the investigation is going on. Now, the reason why you want to do this, okay, is because when you originally file your request for order, okay, and you get your hearing date, when you go to the hearing, okay, more than likely you're not going to get a court order you're not going to get a final custody order that day, okay, because you're asking the courts to do evaluation. All right, so if you're asking the courts to do evaluation, an evaluation takes time. First of all, you're going to have to pay for this evaluation. Yeah, you're going to have to spend some money, okay, in regards to this. All this stuff costs money, and that's it, okay? So if you ain't got a couple dollars just to spend on this, might as well not waste your time. Don't go boo-hooing to nobody, or whatever the case may be, and talking about somebody, pity you because you don't have the dollars, or, go and do a GoFundMe, do whatever. But it's typically, not just what, not attorneys. If you go in pro per, okay, which I suggest you don't do, but if you do go in pro per, have somebody really good, handle your paperwork, okay? You know where I'm at. If those who know, those who know me know where I'm at. If not, you know where I'm at. I'm in Riverside, California. You can just, you can go ahead and Google me. Either Google Xavier Marshall, or you can Google SoCal United, and we should go ahead and pop up. You can get in contact with us. But getting back to it, you can basically it's going to cost you some money. It's going to cost you money for the anger management courses. It's going to cost you money for the supervised visits if you have that. It's going to cost you money to get the evaluation. Now the evaluation, it's going to be about maybe, I've seen anywhere from $1,000 to $2,500, okay? And this evaluation the courts will order both parties to pay half. Now, more than likely, the protected party is not going to pay their half. They're not going to be a little reluctant. They're going to say, I can't afford it. It's this, it's more abuse on me. So be ready to pay the full amount, and ask that the courts credit you, the other parties have. So you don't have to put this in your declaration, or you can put this in your declaration, okay? But nonetheless, you're going to have to spend some money. This evaluation, it costs, whether it be the 3111, I believe that's it, or the 730 or 740, whatever the case may be. Again, check with an attorney or check with me when I'm at the office. I could definitely look it up or whatever the case is. But it's an evaluation, okay? So that evaluation is going to take time. When you get to the court, get back to it, when you get to the court on that hearing date, you're going to have the case continued. Okay. In the meantime, okay, it's going to be continued out maybe 45, 60 days. All right. And the reason why it's going to be continued out is because they're going to have to get, you're going to have to pay the fees. You're going to have to basically going to have to pay the fees. You are going to have to, you're going to have to pay the fees. You're going to have to the courts are going to have to assign an investigator. That investigator is going to need time to go out and visit the homes or do whatever the courts ask, interview the kids, interview you, interview the other party, whatever the case may be. That's pretty much what's going to happen. Okay. Now, once you, getting back to it, once you basically you have all the information, what you want to do is getting back to the schedule, to the visitation schedule. You're going to ask for a step up, okay, and whatever that case may be. Now, you're going to ask for the step up until you're able to get the court. You're able to go to the next hearing and get the and have the courts conclude and write the reports and all that other stuff. Now, what's going to happen is during the time the courts are investigating and stuff, you need to stay on top of whatever it is you need to stay on top of. Be on top of your shit, man. Just be on top of your stuff, okay? And now let me get back to it. Now what's going to happen is when the courts come back with their report, okay, they're going to have the report, okay? And let's say the kids, say they want to be with you half the time. They love you. They want to be with you and all these other things. The court still cannot take that information and, just take that and only that, from the social worker or whoever, okay? Whether it be the social worker or it may be a mediator or whatever the case may be, okay? The courts cannot take all that information, cannot just adopt a new visitation schedule or give you custody based on the fact that the kids want to see you more. Okay, no, it doesn't work like that. Okay, so you may get that, but okay, the courts also want to know if you have been following the orders. Okay, and so that's why you're going to have all the other attachments, and you're going to show the courts that you have been following the order, and in fact, and this is your proof. This is your factual proof. Okay, documents from the respective agencies showing that you have been following this order. And so you're likely, if you are, and let me stop that. Before the court date, okay, if you have made any more child support payments, if you have attended any more classes, it's 60 days probably, 45 to 60 days. So you better have attended more classes. You better have been paying your child support. If you've had more visitation, whatever you have been doing, provide a supplemental declaration to the courts, okay, to let the court know what has been going on. Okay, so while you have been, during this this continuance, okay, you've still been honoring everything. Here's your proof. You've still been, your visitation, everything has been honored, okay? And when, that right there, okay, if you go to court on your hearing date and it's been continued, okay, and if you have a good report, okay, and it is, is backed up with all the other information that you've been showing the courts in regards to your classes, in regard with your anger management classes, your co-parenting classes, or your parenting classes, your payment history for child support if you have one, your visitation schedule, with everything, more than likely, okay. And let me stop that. More than likely, let me hold up. And the other party, okay, if the other party rebuttals, okay, and the other party's rebuttal, all right, meaning in their response, in their declaration, because they, you know, does not show any substantial proof or any further harm, then that will be helpful. Okay, I mean, that will that will be helpful to your situation. Okay, because more than likely the courts will grant you some custody, an increase in your custody, and the only thing it can be is either joint, or it's more than likely it's just going to be joint, but you will have your custody back, because you have rebutted the presumption that that you assisting in the decision making in regards to the kids is in their best interest. Okay, you have rebutted the fact that it's not in their best interest, and it is in their best interest. And the way that you've shown that it is in their best interest is because you have been compliant with all orders. Okay, not because you're doing what she's saying or he's saying, not because the kids love you and all that. No, it's because the courts understand. I mean, the courts are going to recognize that you have been following the rules. Okay, that goes. Wait a minute. Oh man, if some folks turned off this video too soon, they some dumbasses. You should watch this video all the way through, because there may be something I forget, maybe something I remember, maybe something. Okay, but another important thing: do not violate the order. If you violated that court order, that restraining order, okay, whether it be you call that person, and even if it was simple, okay, if it was nothing, means nothing, you text when you wasn't supposed to, you did something, you a fool. Okay, do not violate the court order. Okay, you must always follow that. I should have said that at the beginning, but I didn't. Okay, it is what it is, but do not violate the court order. Okay, so if you have if you did not violate the court order and you have followed all of what I'm saying, at least about 6 months, you should be successful in getting back your custody. Getting back at least some joint custody. All right, as long as you follow those, you follow those rules. Okay, and you don't stay out of state. You don't stay 1 or 2 counties away. Okay, you're within the vicinity, you're able to talk with the other person and all that other good stuff, then you should be good, you should be fine. Now, hope this information hope this information you find helpful. I hope that you share this information. I hope that you use this information, if you're in a situation such as this. And so that's pretty much it. You have a good one. Take care.